Hey guys, I'm here with another bunch of court filings in the Delphi case because Delphi is my life now. One day, sometime in the dim and distant future, I might actually be able to do live streams about other cases other than Delphi. If they wouldn't stop, they just need to stop with all of these court filings. So I was going to do this live stream tomorrow morning, but I thought, you know what? The Adam Montgomery trial finished early because they rattled through a bunch of witnesses very quickly. So, yeah, the jury went home early. I sat down and watched a dog training podcast. And then I thought, you know what? I might as well just do it now. So, aye up. We don't really say aye up round here. It's more of a Yorkshire thing, that. All right. Okay, so we've got 3 orders issued by Judge Francis Siegel, the dishonourable one, and the Supreme Court has spoken. So we know what the Supreme Court decision was, don't we? From the what was that? 18th of January. But they were going to give a written write-up, and they have. It's not very impressive, honestly. I've got to say. It's a bit of a, I don't know what the word is. Bit of a letdown. You know, but at least Baldwin and Rosie were given the, you know, the justice that they deserved. But we'll get to that. So, 3 orders. We're going to say aye up. Do they really? My family from Wigan, and they don't say aye up. Maybe the youngsters do. I don't know. Anyway, so these have all come in today from the dishonourable Judge Francis Siegel. She's actually, you know, looked at the system and actually done some work. So there's that. All right. Well, she's caught up with all the things that are outstanding. So, order issues defendant to respond to the state's motion to compel discovery on or before February 21st. So they've got a couple of weeks. So this was the state saying that they'd not got any discovery from the defence and they want to compel it. Well, if you hadn't have disqualified them, Nicholas, then have been disqualified, you'd have got their discovery in October. But no. All right, so they've got till February 21st to hand over their discovery to the state. Okay, so that's the first one. Second one, the court, having taken defendant's motion to transfer under advisement and having reviewed the state's response, so Slicky Nicky's response to the defence's motion for transfer, now denies the motion to transfer without hearing. So is this the 3rd time the defence has asked for Richard Allen to be transferred to a county jail? So remember, this motion to transfer was put in by Scremin and Labrato before the rightful defence was reinstated. She took it under advisement. But now that Baldwin and Rosie are back, she can now deny it. Because Slick Nick did that beautiful response. I did a video all about it. Beautiful response. You know, when he had to do all that ringing around, he got the surveillance tape from Wabash. Do you know that? Yeah. Well, she was convinced by that. So she's denied. So he's staying in Wabash. And then the third one, this is interesting. Defendant's motion to continue the hearing scheduled for February the 12th is reviewed and granted. She's actually granted a defense order. So the hearing has been reset to March 18th. So we've got another month and a bit to wait now for that hearing. And that will be in her court, the Allen Superior Court. So there is going to be a hearing still. So remember what this hearing is for. This hearing is primarily for the motion for contempt. So I did a video this morning. Some of you will have seen it. Some of you might not. But I did a video this morning all about a response that was sent into the court by a law professor, quite a well-known law professor called Michael Osbrook. And he's put in an interesting, very interesting 8 pages. So I went through it this morning. I'm not going to go through it again, but it is very interesting. So go and either listen to my video or go and get the motion yourself. It's out there. You can just find it. Okay, so those are the 3 orders. Short and sweet. But that kind of brings the Carroll County Court docket up to date, I think. I don't think there's anything else outstanding. So we turn to, presumably, this is going to be the final thing issued by the Indiana Supreme Court. So if you remember from January 18th, the argument was put very forcefully and very expertly by Mark Lehman, acting on behalf of Richard Allen, and Cara Weinecke had co-written, and they asked for 3 things in their writ of mandamus and prohibition. They asked for Baldwin and Rosie to be reinstated, which they got. They also asked for Judge Gold to be disqualified. No, they didn't get that. And they asked for a speedy trial within 70 days. So they didn't get that. So this document here is the full explanation as to how they arrived at their decision. Yeah, Gull has gone rogue, but this has given her ammo. She's got a boost. She's got the only video game I've ever really liked was GTA San Andreas. And you could get some really nice cheats, like to beat the police. Because I could never do any of the missions. I couldn't even do the first mission. So I just used to drive about, nicking cars and shooting the police. And then there were certain cheats that you could put on. And, you could beat the police with cheats. And I rather feel that this has given Gull a little bit more ammo, like a cheat sheet. So it's interesting though. So we're gonna read. I might not read it word for word because it's 21 pages. It's big writing though. So yeah, Gull is an ordinance queen. Yeah, she's something, all right. So this was written by Justice Malta and Chief Justice Rush, and Justices Massa and Goff all concurred. Justice Slaughter, which has got to be the very best name, very best name for a judge, concurs in part and dissents in part. So Justice Slaughter wrote his own opinion. So So the last few pages are what Justice Slaughter thought about it all. So it wasn't unanimous for Rosie and Baldwin being reinstated. They said it was majority, which was fine. So we now know it was Justice Slaughter that was the dissenter. But this is the opinion that all of them agreed on, except for Justice Slaughter. So this just gives the background. So we can probably just skip that. So we explain our reasons for those three decisions. In short, we reinstated Baldwin and Rosie as Alan's court-appointed counsel because the trial court, i.e. Gull, did not find that their disqualification was a necessary last resort after weighing the prejudice to Alan. We denied Alan's request for a trial within 70 days because he didn't make that request in the trial court, which is actually fair enough. I don't disagree with that. And we denied Alan's request to replace the special judge because he did not overcome our presumption of impartiality by identifying facts showing clearly that the special judge is biased or prejudiced. So they couldn't see anything that Gull was doing that was biased or prejudiced. Okay. Well, in their questioning, in the hearing, it was clear that they'd read all of the documents. It was clear that they had a very good grasp of the issues at hand, and they've still come out with they can't see any bias. So you guys, somebody asked me the other day in a live stream whether I thought that the justices, the Supreme Court, would be watching Gull, like a hawk, like a big hawk that kills gulls. And I said, no, probably not. No, I don't think so. And no, I'm sure of it. I don't think they are. I don't think they care. I honestly don't think they care. They don't think it's any of their business. And I think it's very clear by the way this is worded that that's absolutely the case. That they don't think Gull is biased. They think she made mistakes, but they've rectified the mistake by reinstating Baldwin and Rosie. So all's good. In the world of the Supreme Court of Indiana, all's good now. So they're not interested. They're not looking at the filings. They're not. I mean, somebody proved me wrong, but just by the way this is worded. Okay, so we've got some facts and procedural history. Yeah, go on. I'll read all this because I kind of think that we all know all of the basics, but there are people every day who come into cases new. I've been getting questions from people who have just got into the Harmony Montgomery case because it's Adam Montgomery's trial. So I've followed the Harmony case since she was first reported missing, and I just assume people know, and it's not the case at all. So I'm gonna read the procedural history just to so we're all clear. Oh, I was trying to have a drink from the wrong side of my can of pop then. Okay. So February 2017, two teenage girls, Abigail Williams and Liberty German. Look, guys, look. The victims were named. Wasn't it the naming of the victims that Judge Francis Gull said was the reason that the Franks memorandum had to be hidden from public view? Yeah, that's exactly what she said. Well, the Supreme Court justices don't have problems naming child victims because they're deceased. They're deceased. Were killed in Delphi, Indiana. 5 years later, in October 2022, Alan was arrested and charged with murdering them. The trial court judge transferred Alan to the Department of Corrections for his safety. Okay, yeah, that went down well. Yeah, that's aged well, that has. Well, he waits trial and then recused from the case. So that was Judge Dina. So the day he ordered Alan to go to Westville Department of Corrections, he recused himself because of the bloodlust. The bloodlust, he said, because of bloodlust. All right, then. A special judge was then appointed. And because Alan couldn't afford an attorney, the judge appointed Baldwin and Rosie to represent him at public expense. That was mid-November. A year later, the special judge lost faith in their ability to assist Alan with his defence effectively, even though they were appointed mid-November. I'm going to fill in some of the blanks here. They're missing a lot out. They were appointed on or about the 14th of November, sticks in my head. So it was mid-November. And the press release that Gould's got a problem with, one of the things that she claims was grossly negligent, and one of the things now that Slicky Nicky is saying is evidence of contempt of court, was Baldwin and Rosie releasing a press release on the 1st of December 2022. However, that was before the gag order. Anyhow, I digress. You know, she can't come along a year later with things that happened like months previous without saying anything about them. It's bullshit, honestly. Okay, so year later, the special judge lost faith in their ability to assist Alan with his defence effectively, so she ultimately disqualified them as counsel. A leak of confidential case materials, including crime scene photos, triggered the disqualification. Baldwin and Rosie represent that in... What? That doesn't make sense. Baldwin and Rosie represent that in August 2023, one of Baldwin's friends and former employees, Mitchell Westerman, visited Baldwin's office, secretly copied discovery materials, which he's admitted to. Okay. I'd love to see the discovery in that case. I'd love to see. Slicky Nicky's got his hands all over Mitch Westerman's discovery. How has Slick Nick, the Carroll County prosecutor, got his hands on the discovery materials from Mitch Westerman's case? It's a completely different case, not being tried out of Carroll County. He's not part of the Indiana State Police. How does he get his hands on that stuff? Asking for a friend. Right. Okay. After discovering the leak, Baldwin and Rosie notified the special judge and the prosecutor on October the 6th. They also explained that after Westerman told Baldwin on October 9th what he'd done, Baldwin and Rosie relayed the information to the prosecutor the next day. Again, they're missing tons out. They're missing out the fact that Slicky Nicky already knew about this stuff. Right? And according to Slick Nick, it was the girls' families that were notifying people. According to Slick Nick's contempt document. Right? So that was October the 4th into October the 5th. But anyway, he knew. He was starting to investigate. It was his idea to disqualify them. 2 days later, the prosecutor emailed defense counsel and the special judge informing them that the individual to whom Westerman allegedly provided the materials committed suicide hours after refusing to answer questions from an Indiana State Police detective investigating the leak. Well, we'll never know what Robert Fortson said or didn't say to the Indiana State Police because sadly is no longer with us, so we just have to take their word for it. The special judge responded to the email by expressing that she was deeply concerned that Mr. Allen's defense is being compromised by all these recent events. She then directed defence counsel to stop working on the case until the judge could discuss the recent developments with the parties during an October 19th hearing. Again, I'm gonna add some bits here because they're a bit scant on the details. So she told them to stop working on his defence on October the 12th. Right. During that week, Slick Nick had been able to, get all of his friends from law enforcement to attend this hearing on the 19th as witnesses. Yet Baldwin and Rosie didn't know what the hearing was about. We've seen the emails. Rosie even asked what this hearing is about. And he was told, you and Andrew turn up 12:30 to my chambers. Right? We can have a chat before the hearing, which was due to start at 2. Once they got into her chambers, they were ambushed. She had the cameras there waiting for them so that she could shame them. They're missing all of this. This is the reason why they're saying that she's not biased, because they're missing all the important bits out. Okay. Meanwhile, Alan wrote a letter to the special judge informing her that he had discussed the leak with Rosie and the impact it could have on his defence, but that he wanted Baldwin and Rosie to continue representing him. Counsel for both sides met with the special judge in her chambers just before the October 19th hearing to discuss the court's expectations for the hearing. Well, Slicky Nicky already knew what the hearing was about because he had all his witnesses, like Jerry Holman from the Indiana State Police, Doug Carter from the Indiana State Police. I don't know who else was there. How did they know to turn up? Do they communicate telepathically or what? They have a hive mind. No, they were told to turn up as witnesses because this was, in Slick Nick's mind, a disqualification hearing. Unfortunately, though, they omitted to tell Baldwin and Rosie, the subjects of the disqualification hearing. They had no idea what the hearing was actually about. We've seen the transcript. We know how underhand it was. Okay. So they met in her chambers. During that meeting, the special judge informed Baldwin and Rosie that they had demonstrated gross negligence and incompetence and conveyed she had grave concerns about their representation of Alan. In support, the special judge said the attorneys failed to safeguard confidential case materials, including crime scene photos, emailed confidential work product. Thank you. It was Baldwin's own work product, not discovery. So I'm glad that you actually got that bit right. To an unauthorized person and failed to timely report the leak. I don't know that he was expected to, because he told Brandon Woodhouse to delete the email. It's not Baldwin's fault if Brandon Woodhouse didn't delete the email and shared it out to his friends, for his YouTube channel. We've probably all done it when autocorrect puts an address in that you didn't intend. I've done it myself. Okay. Make extra judicial statements about the case. They've never done that. And including accurate statements in various pleadings. Yeah. Them saying how bad Richard Allen was being treated. But oh no, the warden of Westville is going to come along and say, oh, everything's hunky-dory. Richard Allen's having a great old time. It's like a holiday camp. No. Based on these concerns, the court informed counsel that she decided to disqualify Baldwin and Rosie, but she offered to let them save face by withdrawing from the case so she wouldn't have to go into public hearing a few minutes later and read a statement that she'd prepared explaining why she believed counsel were grossly negligent and ineffective. Alan wasn't present for this discussion, But he wanted to go. He was willing to go to the judge's chambers to talk to her. Richard Allen was in the building and she said, no, I don't want him in my chambers. That's what she said. Briefly speaking with Baldwin and Rosie, he relayed through them his objection to the court's disqualification. Since the court presented to Baldwin and Rosie what seemed like a Hobson's choice, withdraw or be disqualified, in a publicly humiliating fashion, they conveyed that they would withdraw over Allen's objection to the court's disqualification decision. The special judge accepted their withdrawals and conducted a brief public hearing without them, where she stated merely that there was an unexpected turn of events. There was nothing unexpected about it, was there? She got a prepared statement. But after having a few days to reconsider and discuss it further with Allen, defence counsel changed their minds. They'd never had their minds altered. They said what they needed to say so that they weren't going to be ambushed in public in front of the world's media. Yes, it was saving face. But that was the best outcome of a very, very poor situation that they had no idea about beforehand. Okay, neither Baldwin nor Rosie ever filed a written motion to withdraw as required by trial rule. I'm glad that they're going by the rules. This is what I've been saying all along. Just saying you're going to withdraw isn't the same as withdrawing. That's what I've been saying. Neither of them filed a motion to withdraw. Therefore, neither of them actually withdrew. Okay. Instead, Rosie filed a verified notice of continuing representation, notifying the court that he, in fact, would not be moving to withdraw and would continue representing Allen. And he filed a motion to disqualify on Allen's behalf, arguing the special judge was biased and should recuse herself. The trial court struck both filings and ordered the clerk to remove them from the record because Rosie was no longer counsel of record. She also appointed 2 new public defenders to represent Allen. Baldwin then filed a motion to reconsider, also informing the court that he would not file a written motion to withdraw. He did not consider his oral withdrawal effective, it wasn't, and would continue representing Allen. Baldwin and Rosie both entered new appearances as Allen's privately retained pro bono counsel. But after a hearing on August 31st, once again we have the transcript for this, the court entered an order stating that the special judge previously found gross negligence by Baldwin and Rosie in the representation of the defendant. And nothing has changed in the intervening 12 days that removes the court's grave concerns about their representation. So over their strenuous objections, the court disqualified them from representing the defendant and affirmed the appointment of new public defenders. So that's Scremin and Labrato, for those not keeping up at the back. The court also continued the January 8th trial date to October 15th, 2024. We should have been done and dusted with this trial. It should have finished. Was it scheduled to last 3 weeks, I think? So it would have been done. Richard Allen could be sitting at home now, having been acquitted. Think on that. On November 6, 2023, Allen petitioned this court for a writ of mandamus by original action and asked us to 1. Order the trial court to reinstate Baldwin and Rosie, 2. Order Allen's trial to begin within 70 days, and 3. Replace the special judge. We heard oral arguments on January 18th. So this is the discussions. That was all the background. So we're all up to date, caught up. Okay, discussion. We explain below, we agree with Allen that he is entitled to have his original court-appointed counsel reinstated, but we agree with the state and the special judge that Allen is not entitled to a writ ordering a trial to begin within 70 days or replacing the special judge. Okay. So now this is their explanation. Alan's request to reinstate his original court-appointed counsel presents extraordinary circumstances warranting relief. Alan argues the trial court exceeded its authority by disqualifying his original court-appointed counsel because disqualification was unwarranted and significantly prejudices both his defence and his opportunity for a speedy trial. And who created that prejudice? Like, all they need to do is take one step further in their thinking processes. So it was unwarranted and significantly prejudices his defence. Therefore, we've got to look at, well, where did this prejudice come from? What was the cause of that prejudice? Oh, look, it's the judge who's meant to be impartial. I can't see how they can't grasp that she's got this massive bias. I can't see how they can't. I don't know how they can't grasp that. Anyway, they haven't. The state and the special judge respond that this original action is not the proper procedural vehicle to evaluate Alan's claims. And even if it was, the special judge was within her authority to disqualify counsel because she was rightly concerned that they were not fulfilling Alan's constitutional right to effective legal assistance. To be honest, I don't know how more effective they could have been. Their defense is spectacular, incredibly good. Whether you believe the Odinist theory or not, you've got to admit it's a good theory based on a bunch of evidence in the state's own discovery. And the stuff we talked about yesterday, if you watched the live stream from last night, wow. Deleting interviews. Go and watch last night's live stream if you don't know what on earth I'm talking about. It wasn't a long one. We agree with Alan. Our court has repeatedly reviewed attorney disqualification issues through original actions, and we do so here because Alan's petition presents the sort of extraordinary circumstances for which there is not an adequate appellant remedy that our original action rules require. Good to know. We may review an attorney disqualification decision through an original action. This court has exclusive original jurisdiction to supervise the exercise of jurisdiction in all Indiana courts. Good to know. We exercise our super. Okay, so we can skip this. Okay. One issue our court has repeatedly reviewed through original actions is whether to disqualify counsel. Okay. All right. So those are all the cases that they're going to bring up as sources, as reference. As in those prior cases, reviewing the trial court's disqualification decision here is appropriate through an original action. That is because this case presents extraordinary circumstances where denying a writ will result in substantial injustice. And who created the injustice? The judge, who is meant to be impartial, who is holding the scales of justice so that both sides can have equal weight. Dear God, that is because this case presents extraordinary circumstances where denying a writ will result in substantial injustice. Alan's petition is not a substitute for an adequate appellant remedy. We reach that conclusion for a few related reasons. For starters, disqualifying Alan's counsel delayed his trial by at least 9 months, and the trial court has already concluded that Alan's pre-trial confinement presents extraordinary challenges. Well, I'm glad that they recognise that. So if they'd like to step in and ask Judge Gull why she's constantly denying transport orders, I don't know. I'm just suggesting that they might. They won't, for the reasons I've already said, because they don't care. They consider this done. They're not watching the docket, in my opinion. Okay. Normally, criminal defendants must be confined while they await trial and detained in a county jail. Oh! Really? with other defendants who are awaiting trial or have been convicted and received short sentences. But here, for Alan's safety, the original judge transferred Alan to the Department of Correction, which runs our state's prisons, facilities that generally detain inmates only after they are convicted and serving longer sentences for more serious crimes. The special judge later reconsidered the original judge's transfer order, and she too found it reasonable and necessary to ensure the defendant's safety and to prevent serious bodily injury. So he's lost almost half of his body weight. Is that normal in just a few months to lose almost half of your body weight? What is it, some kind of fitness boot camp where he's getting, like, I don't know, green juices in the morning and a personal trainer to help him do squats and sit-ups? No. To lose half of your body weight, you're not eating. Why are you not eating? What were they doing to him? What were they doing to him? I used to drink green juice in the morning. Stop doing it. It's to make me fart really badly. I'm sure you didn't want to know that. That was a bit TMI, wasn't it? Yeah, well, anyway. Okay, Alan is being held at the Wabash Valley Correctional Facility, which is hours from Carroll County, where the charges are filed, and Allen County, where the special judge serves. Alan's original public defenders and his substitute public defenders have all challenged the conditions of his pretrial confinement, including as they relate to preparing his defence. We are in no position to evaluate the claims of... Well, if they're not in a position to evaluate this, who is? Who is in charge of that? Who? Well, is it the Attorney General or who? Because everybody seems to just be washing their hands of it. Oh, I can't deal with that. That's not my job. Well, whose job is it then? Okay. And the special judge has concluded at least some of Baldwin and Rose's claims about the confinement conditions are wrong. Well, what about the new transfer? I mean, obviously they won't have seen this, that Scremin and Lovato wrote about both Westville and about Wabash, that today Judge Gull has denied. What about that? It's not just Baldwin and Rosie that are complaining about the treatment and abuse that Richard Allen is facing. But even assuming every aspect of Alan's pretrial confinement is proper, it isn't. And again, we are in no position to say one way or another. Extending it for at least 9 months still presents extraordinary challenges for which there is no adequate appellant remedy. Well, why not grant the speedy trial then? Given all the new discovery that Slicky Nicky found down the side of his sofa, it's actually probably a good job that they didn't file the speedy. Breathe. Oh, dear God. What's more, as we explain in greater detail below, we've concluded the trial court lacked the authority to remove counsel without, 1, considering other less drastic options, 2, weighing the prejudice to Alan. Once again, where's the prejudice coming from? No one except Judge Francis Gull. Well, actually, it's really the prosecutor. But Judge Gull is taking his side without any real thought. So whose side is she on? So not only would Alan's trial be delayed for at least many months if his original attorneys were not reinstated, If Allen were convicted, correcting the disqualification by vacating his conviction and ordering a second trial would produce years of further delay and an enormous waste of time and resources. That would not serve anyone's interest, not Allen, not the state, the victims' families, the courts, or the public's. Good. Thank you. You get a gold star for that sentence. Of course, these concerns can generally be resolved through discretionary interlocutory appeals. Okay. Blah, 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 blah. So appellant will suffer substantial expense, damage, or injury if the order is erroneous and the determination of the error is withheld until after judgment. Or the order involves a substantial question of law, the early determination of which will promote a more orderly deposition of the case. I don't understand what that means. And both the state and the special judge argue that it's the procedural route Allen should have pursued instead. So should have appealed, but would have been absolutely pointless. Allen effectively couldn't, exactly, which is another reason this matter is extraordinary. On top of disqualifying counsel, the special judge struck their later filings because they were no longer counsel of records. Without the ability to file a motion requesting the special judge to certify or order for an interlocutory review, Allen's attorneys couldn't pursue the avenue. Good. To that point, the state and the special judge respond that Allen should have either his new public defenders or the appellant attorneys he retained for his original action pursue an interlocutory appeal instead. But it isn't clear how either option was feasible. The newly appointed trial counsel had nothing to do with the disqualification, and Allen wasn't present for them. So it's not obvious how Allen could work with his new trial attorneys to pursue an appeal in the trial court. And it would have just been pointless because who's the trial court? It's goal. What point would it have been? Just add more months on and more expense and more trauma. Maybe Allen's privately retained appellant attorneys could have done so, but it's unclear whether the trial judge would permit them to represent Allen in the trial court along with his new substitute court appointed counsel. It's unclear how it would work if substitute court appointed trial counsel disagreed. Okay, all right. So they don't expect Allen to have to deal with that. Good. Allen is entitled to the reinstatement of his original court appointed counsel. So they may only be disqualified as a last resort after considering the prejudice to the defendant. Sixth Amendment of the U.S. Constitution, applicable to Indiana through the 14th Amendment's due process clause. Okay, lots of law. Section 13 of the Indiana Constitution guarantees criminal defendants the right to have an attorney assist them in their defense. In all criminal prosecutions, the accused shall enjoy the right to have assistance of counsel for his defense. Okay, the accused shall have the right to be heard by himself and counsel. For defendants who can afford to hire an attorney or retain an attorney to represent them for free, that constitutional guarantee includes the right to choose which attorney will represent them. So it's interesting, isn't it? Because that doesn't work for public defenders. Because if they disqualify a public defender, or the public defender recuses themselves, they just appoint a new public defender. So you fulfilled the constitutional rights to have counsel, but it's not a counsel necessarily of your choice. You're just given someone. You know, it's pot luck. But the fact that they re-entered themselves as private counsel, I don't know whether that had any impact or made a difference in their thought process. Maybe I should just carry on reading. Maybe they say, maybe they don't. And the erroneous deprivation of this right constitutes structural error, which, unlike other errors, entitle criminal defendants who are convicted to automatic reversal and a new trial. So So it would have gone to a new trial. So the first trial would have just been a show trial, would have been a practice run to get all the discovery in order, find all the interviews that seem to have got lost. Find audio recordings, look for backups of audio recordings that were recorded over. Oh my word. The right to counsel of choice does not extend to criminal defendants who can't afford an attorney and can't find one to represent them for free. Alan can't afford an attorney, and he has asked us to reinstate Baldwin and Rosie as his court-appointed counsel. Consequently, he has no constitutional right to choose which attorney will represent him. But he didn't choose Baldwin and Rosie. The trial court did. Alan just wants to continue with the attorneys the trial court chose for him. He is insisting on the continuity of counsel rather than his choice of counsel. That's interesting. That's really interesting. So I'm glad that they looked at it like that. Because now in future cases in Indiana, if a judge tries something similar, they can look to the Supreme Court judgment here and say, look, my client has a right to continuity of counsel. So the argument about, oh, well, it's a public defender and you don't have a right to choose a public defender. Well, the Supreme Court of Indiana is saying that they actually should have continuity of counsel. So that's good that that's actually in writing in a Supreme Court order for Indiana. If you're in Indiana, it's good. Courts around the country are divided over whether the Sixth Amendment guarantee criminal defendants the continuity of court-appointed counsel. There is no constitutional right to continuity of appointed counsel, someone has said. Once established, the interest in maintaining a relationship of trust with counsel is of no less importance to an indigent, it's another word I struggle with, client than one with ample resources to hire counsel. I'm glad this is all in writing. Our court has been generally of the view that a trial court is limited to its authority to remove a criminal defendant's court-appointed counsel. And even courts that have concluded there is no Sixth Amendment right to the continuity of court-appointed counsel have agreed with that much. That's really good. Really good that is written down with the Supreme Court stamp on it. Krista, thank you. That's very generous. $49.99. Thank you so much. You're always hopping in with big donations. You're very much appreciated. Very much. While we've got a little lull, on my screen here, it's telling me that this stream has only got 5 likes. I don't often ask for likes, but it does help. It does help to push this live stream out in the YouTube algorithm. Christine hopping in with £10, my own currency. The judge can't dismiss and handpick the lawyers. That would make the judge biased. Exactly. That goal is so crooked. I can't believe this Supreme Court and I'm embarrassed for them. I agree with some of what they said. I'm glad that they've got this bit written down. But how they've come to the conclusion that Judge Gull isn't biased, I can't work that out. I've not worked that out yet. All right, so we've got 200 and something likes. Oh, I'm glad. It just hasn't updated then on my end. So that's good. But if you haven't liked the stream and you're liking the stream, then give it a thumbs up. It takes a second. Okay. For example, through the Colorado Supreme Court recently held there is no Sixth Amendment right to the continuity of court-appointed counsel. It still acknowledged that a defendant's interest in continued representation by a lawyer that they've been working with entitles great weight. So this is all good. Good for Colorado. So we've got some more kind of amendment stuff there. You can read all this yourself. It's dead easy to get hold of. If you just go to my case and type in Richard M. Allen, then you'll get the Carroll County, you get this one in the Supreme Court. And you can, these are clickable links, so you can just click the link. Oh yeah, if you're in Europe though, you'll need a VPN because it won't let you on without a VPN. Just gives you like a really nice blank screen. Spike the likes. Yeah, spike the likes. How many have we got in chat? I've not given away any memberships for a while. 600 and what? 606 watching. So I don't think we're going to make the 1,000 likes. Not enough people in the chat. 1,000 likes, I give away 20 memberships, but you have to recruit some more people to hop in and click the like. Okay, so where was I? So Colorado Supreme Court also recognised that before disqualifying court-appointed counsel, the court must determine that any remedy short of disqualification will be ineffective. Yeah, she did nothing. She did nothing. In other words, disqualifying court-appointed counsel is a drastic remedy that should only be a last resort. Courts should therefore disqualify counsel with considerable reluctance, only when no other practical alternative exists. Thus, disqualification of defence counsel should be a measure of last resort, and the government bears a heavy burden of establishing that disqualification is justified. Very good. And this approach aligns with how we have treated other drastic litigation remedies that are in tension with parties' due process rights. Okay, good stuff. Trial court has broad discretion in determining whether to declare a mistrial, and ordinarily the prerogative to declare one will be exercised only as a last resort. Yeah, but the way this is going, if it gets to trial, the way this is going, it's going to take years to resolve one way or another. While the state defends the disqualification decision here, it appropriately acknowledges that a trial court's discretion to disqualify court-appointed counsel is significantly limited. The state's brief accurately explains that while varied interests may necessitate overriding a defendant's preference, disqualification is an extreme remedy that should only be used when a court deems it reasonably necessary to ensure the integrity of a fact-finding process, fairness or appearance, fairness of trial, the orderly effective administration of justice, or public trust or confidence in the criminal justice system, of which there is none anymore in this case. I don't think anybody trusts this case now. Whether you firmly believe that Richard Allen's guilty, or whether you firmly believe that he's innocent, or whether you're somewhere in the middle and weighing up all the different theories and just being very open-minded like I am. Wherever you are on that continuum, you've got to agree that what has gone down in the last few months is extraordinarily ridiculous. There's no words for it. No words for it. So whether as a product of the defendant's right to due process or the right to counsel, the bottom line, I'm glad they got to the bottom line, at the bottom, is this: a trial court cannot disqualify court-appointed counsel over the objection of both the defendant and the appointed counsel unless disqualification is a last resort. Disqualification is necessary to protect the defendant's constitutional rights, to ensure the proceedings are conducted fairly and within our profession's ethical standards, or to ensure the orderly and efficient administration of justice. And those interests outweigh the prejudice to the defendant. Okay. So that's the reason why they reinstated Baldwin and Rosie. Okay. So in a previous original action, we said a trial court is limited in its authority to remove a criminal defendant's court-appointed counsel, but we went on to say it was unnecessary to explicate the parameters of that authority. While an original action is not the appropriate vehicle through which to adjudicate or establish a right or to define or impose a duty, here we do find it necessary to explain the parameters of the previously established limitations on the trial court's authority. Yeah, because she's been such a dickhead. They've had to spell it out in syllables of like one. Because it seems that Judge Gull has a reading ability of a centipede. How did she pass the bar exam? Like, what did she do? Did she bribe the person who marked her exam papers? I'm starting to wonder. The framework we describe here mirrors how our court has treated other drastic remedies and may conflict with parties' due process rights, and our concerns that disqualifying counsel introduced structural error. And Justice Rush was going on, banging on about structural error. She just kept saying it. At least as it relates to disqualifying them as privately retained pro bono counsel, presents further extraordinary circumstances that prompt us to exercise our jurisdiction now to preserve the integrity of the trial proceedings going forward. That is a big statement to make. That's a big statement to make. However, they didn't go far enough. They didn't take that one extra leap and think, well, where has this prejudice come from? Why did they not do that? Maybe because they're friends of Gull. Maybe they have little dinner parties and, you know, I don't know, go on family outings. I don't know what they might do, but yeah, maybe there's some, you know, judge solidarity going on. Maybe that's what it is. So disqualification was not the last resort. The special judge concluded Baldwin and Rosie made 4 mistakes that demonstrated they may be unable to assist Alan in his defence. They failed to secure confidential case materials, including crime scene photos. Baldwin misdirected an email, he says inadvertently, with confidential case materials. No, you got it right the first time. It wasn't case materials. It was work product. It was an index. All right, you have people's names on it, you know, like such a body's interview and such a body's interview, but there was no case materials in it. To a non-party client without timely reporting the mistake to the trial court or prosecutor. He told Brandon Woodhouse to delete the email, and he didn't. So it's not Baldwin's fault. It's a mistake. It's not gross negligence, though. Baldwin and Rosie made extrajudicial statements while the prosecutor's motion for gag order was pending. Doesn't matter what was pending. It wasn't granted. Wasn't granted. So it doesn't matter if it was pending. Irrelevant. Which the special judge thought might prejudice the case. And 4 statements in Baldwin and Rosie's motion. And these things were in December of 2022. So Baldwin's emailing mistakenly Brandon Woodhouse instead of Brad Rosie was in December. And the press release was in December 2022. So can't be that bad, can it? You know, they had to wait 10 months to disqualify them. Come on now. Come on now. But the record does not reflect the special judge disqualified counsel only as a last resort. No, there was no record. There was no record because she was just willy-nilly deleting everything. She was trigger happy. Delete, 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 delete. Does anybody watch Doctor Who? Like, is Doctor Who like international? I haven't watched it since, what's his name left? 10. David Tennant. Helen, thank you so much for the £10. Thank you, thank you. But the Cybermen. Delete, 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 delete. In the next hearing, she's going to come along dressed as a Dalek. Exterminate, exterminate. If you don't know what I'm on about, I've not gone mad. It's like Doctor Who's a big thing over here. But like I said, I haven't watched it for years. It was when Matt Smith took over. I really tried to like Matt Smith, and then who was after him, Peter Capaldi. I tried so much, but the storylines just didn't. They just changed it all. I didn't like it. I wanted David Tennant back and Rose Tyler. I wanted them back. Anyhow, I digress. I'm going to have to go and get a drink in a minute. I'll read a few more lines and then I'll put my please hold thing on for a minute. Hey, first, the record does not reflect that disqualifying counsel was a last resort. Yeah, exactly. Each of the special judge's 4 concerns could be addressed through a combination of procedural rules and court orders, including the gag order and protective order she entered. Exactly. She's already done what she needed to do. They've not issued another press release, have they? No. They haven't broken the gag order. They haven't. Trial courts maintain both statutory and inherent authority to compel compliance with their orders and procedural rules through contempt proceedings and sanctions that include fines and even jail. So, isn't that interesting, boys and girls? Matt Smith wasn't that bad. It grew me a bit. There was a couple of episodes that I liked. The one with James Corden in that house. I liked that one. There was another one that I quite liked. But it was the storylines. They just didn't hook me. They didn't. And his companion I didn't like either. Listen. Isn't this very convenient? Now, this only came out today. This came out today. Isn't it interesting that they've suggested that one of the ways compliance can be assured, that includes fines and even jail? They suggested it. And when was it? January 29th, was it? That Slick Nick put in his contempt motion. Is it possible that Gull had been tipped off? You know, she's friends with one or more of the justices because she's trying her best to be a justice herself. And she keeps getting turned down, apparently. So she's got friends in high places. Is it possible that they tipped her off and said, what you should have done really is go through the contempt route? So she got on her bat phone to Slick Nick. They work with burner phones, you see, and said, Nick, here's a way that we can get rid of these guys. Here's a way that the Supreme Court will approve of. I don't know. I don't know. I'm just saying. Is it possible? Yeah, it's possible. Okay. So, these people recognise that a trial judge can protect the court against insult and gross violations of decorum. Telling the judge to F the F off. I couldn't sit. I couldn't sit and listen to this bullshit. I couldn't. I don't have the self-control. I'm quite impulsive with certain things, and I can't hold my tongue. I could not go and sit in one of these hearings with her. I couldn't. I'd be on contempt. I'd end up in jail. I'd be hiring Baldwin and Rosie to get me out. I'd end up in the Department of Corrections myself. I'd be fuming. I'd be like that guy. Did you see that clip? I put it on Michelle Walks. That clip of that guy who was being sentenced and he just drove over at the judge and like knocked her in the head like she was injured. I'd be like trying to hold myself back. I'd be like Cassie when she sees a bird. Like she just like she can't help herself. Oh dear. Dear me. By the infliction of summary punishments by fine, imprisonment, or both, via a contempt citation. I'm going to look that up. I'm not necessarily going to discuss it now, but I'm going to look it up. Indiana Code. Oh, the cat's meowing now. She's obviously found her bowl has got stale food in it. Right, 34, 47, 21. 34, 47, 21. Civil law. All right, I'm just going to save that. I'm not going to discuss it now because this stream's already long enough. But I'm just saving that. For future reference, I'll read that later. Or maybe tomorrow because it's like gone 10:30. And I'm going to compare that with what Slick Nick has put in his thing. Indeed, the trial court's protective order invoked the court's contempt power to enforce compliance. All right, okay. So we know now where they got that idea from. There's no finding that these tools were inadequate to resolve the special judge's concern. So you should have held them in contempt. Shouldn't have just disqualified them and deleted every piece of information. No, you got to preserve the record. See, this is what Rosie and Baldwin are doing really well. Really well. Like the stuff that they've been putting out creates a really strong record for future reference because they're clued in. They know that more than likely if Judge Gull stays, they're not going to get a fair trial and it will go to appeal. They're preserving the record. They're creating a really strong record for an appellate court to come along and say, look, this is wrong. Hopefully. Yay, Suzanne, thank you so much. Gifting 5 memberships. Who's got them? Leah, Elizabeth, Marissa, Sky Blue, and Karen. Welcome, you guys. Thank you so much, Suzanne. That's very kind of you. Welcome, welcome. Get a month's free memberships, courtesy of Suzanne. Go and watch my bloopers. They're funny. Me falling all over the place. People say, how could Nicola Bully fall in a river? Well, I fall all the time. I fell in brambles yesterday. It was funny. I didn't put it on my bloopers, though. It wasn't that funny. I was just glad that it was winter. They weren't that high. Else it could have been very painful. All right. Don't do that in summer. When you're like not wearing a coat. I think that would have been very painful. Okay. Second, the only basis for disqualifying counsel was the special judge's concern that they could not assist Allen in his defence effectively. Respondent, blah, blah, blah. To be sure, the Sixth Amendment right to effective counsel imposes a baseline requirement of competence on whatever lawyer is chosen or appointed. But there's no suggestion that Baldwin and Rosie are out of their depth. No, they're two of the most experienced lawyers in the flaming state. Baldwin has over 30 years of experience representing thousands of clients around the state, including clients charged with murder, rape, robbery, burglary, and other violent offences. He has tried more than 125 jury trials. Rosie has over 20 years of the same experience, including 3 murder trials and a previous certification to handle death penalty cases. And honestly, as long as they're a lawyer, if you want a bad lawyer to stay with you, then that's your choice. Like, you can represent yourself, can't you? So it's up to you. Moreover, neither the state nor the special judge argue that counsel's extrajudicial statements or the statements in their motions harmed Alan's defence. Well, it's harmed now, because he's having to sit in flaming Wabash for the next 9 months, at least. They do argue the disclosure of case materials undermines Alan's defence, but they don't explain how exactly. They don't argue these mistakes reflect that Baldwin and Rosie are incompetent to handle Alan's defence, or explain why disqualification is necessary to protect Alan's right to effective assistance of counsel. She's getting a right spanking here. A right spanking. However, how can they say she's not biased whilst simultaneously giving her a right spanking? Notably, neither the state nor the special judge direct us to any case concluding that issues like these, either in isolation or combination, rendered counsel constitutionally ineffective or were sufficient to warrant disqualification. Third, there is no showing that the special judge concerns outweighed the substantial prejudice to Alan from substituting counsel. Baldwin and Rosie spent a year working with Alan, investigators and experts, developing Alan's defence, and Alan says he was ready to present it to a jury. Yeah, and that scared the shit right into Slick Nick's pants. That's exactly what happened. The prejudice to Alan begins with the fact that information and momentum spillage is inevitable as one trial team hands a complicated case like this over to another. Add to that, Alan has already been in jail. No, he hasn't been in jail. He was only in jail for a handful of days. He's been in a maximum security state prison. He's not been in jail, sitting about with a TV like Brian Kohlberger with lovely meals. Brian Kohlberger looks like he has been having green juice every morning. He looks healthy now, whereas he never did before. He's getting proper meals now. Dear God. For a year and a half now, substituting counsel requires a 9-month delay. Well, the delay's already happened, so we can skip some of this. It's not surprising, given that this is a complicated, high-stakes case. No shit. Further, it's already been 7 years since the murders, and fact-finding only gets harder as time passes. Memories fade and evidence is lost. Yeah, recordings. Recordings are just, I don't know, recorded over. Or, there's no audio on this drive. Where's all the interviews with Brad Holder and Patrick Westfall gone? Oh, no, someone's taped over it. There's nothing there. Dear me. Oh, dear God, this record does not reveal any weighing of these concerns. No, because she didn't have concerns like that. Okay, so does not reflect disqualification, blah, blah, blah. Alan's remaining requests present no extraordinary circumstances warranting relief. All right, buckle up. Buckle up, ladies and gentlemen. It's about to get rocky. Alan's second request that we mandate that the trial court order Alan's trial to commence within 70 days. Alan and his attorneys prepared and signed a speedy trial motion, but they never filed it with the trial court. Until a trial court has refused to rule properly, there is no basis for relief in this court. I agree with that. I think we all knew that they weren't going to grant the speedy. But, okay, so they deny that. All right. Alan's third request that we appoint a new special judge to avoid the appearance that the trial judge is biased against the defence. But Alan has not stated facts showing clearly that the special judge's disqualification is required. What? What? Are you kidding me? Are you kidding me? They've gone, we're on page 15. So there's been some really good statements of what the trial court did wrong. and it creates prejudice in Alan's case, yet they've not said anything about how the judge is biased. I'm not with you. Yeah, come on now. Get the come on now emojis in the chat. Ridiculous. Listen, this is just crazy. We'll begin with the presumption that a trial judge is unbiased. Well, we'd hope so, yes. To overcome that presumption, the party seeking disqualification must identify facts reflecting the judge's actual bias or prejudice. Our law is well settled that prejudice is not inferred from adverse judicial rulings. Well, how can you prove it then? How can you prove that a judge is biased without looking at their rulings? Because that's what judges do. They rule on things. No. So how can you prove a judge is biased if you can't use rulings? It's all Alan identifies here. The special judge's adverse rulings disqualifying counsel. Yeah, but the ruling had absolutely no basis, no record. You've admitted that it was wrong and there was a bunch of other stuff she could have done if she thought there was an issue. Oh, come on. This. I told you to buckle up. This is crazy. This is crazy town. No doubt the adverse rulings were significant, but nothing in the record suggests the special judge's decision emerged from bias or prejudice against Alan. What did it emerge from then? Why did she do it then? I mean, no way. Just the opposite. The special judge explained she disqualified counsel because she was trying to protect Alan's right to the effective assistance of counsel. Come on now. You didn't believe that baloney, did you? Come on now. You're like high up there in the uppers of Indiana. And you believe her shit? Come on now. You're a friend. She's got to have friends. She's got friends here. They go for dinners. They have little parties. They have little barbecues in the summer. They're probably all on each other's Facebooks. Oh, man. We don't minimize her concern. She faced a significant dilemma. Yes, she did face a significant dilemma. Slicky Nicky was crying in her ear late at night, saying, I'm not ready to go to trial yet. Oh, what can we do? Oh, I've got to get rid of these people. Can you get me a gun? I want to murder them. And instead of that, she said, come on, Nicky, calm down. Calm down, Nicky. No one needs to die for this. Okay, what else can we do? Well, I wasn't disqualified then. Okay, Nicky, you do that. Oh, dear. Dear. If there was any, wouldn't it be brilliant if you could find proof of like secret phone calls and secret meetings between them? Wouldn't that just be brilliant? I'm killing you. Wouldn't that just be brilliant if we could find some evidence? Have we got any hackers? You know, it's like tap the phones or something. Little bat phones that they've got, little Nokia burners. I don't know. Not saying that you could go and hack anybody. That was a joke, by the way. Okay. If she left counsel in place and Alan was convicted, the conviction might have been vacated through post-conviction proceedings based on ineffective assistance of counsel. Well, what's it going to be based on? It's going to be based on ineffective judging. That's what it's going to be based on in the appeal courts. I can see it coming now if he survives that long. Or she disqualified counsel and Alan was convicted, then the conviction might have been vacated because she infringed on Alan's right to the continuity choice of counsel. She was in a tough spot either way. Yeah, she was in a great tough spot trying to deal with little Slicky Nicky's little tantrums on the phone or something. Though we've determined the record does not support a disqualification decision, we reach that conclusion with the benefit of weeks to consider the issue, thorough briefing and oral argument from excellent appellant attorneys, and the benefit of 5 justices and their staffs poring over the records, authorities and arguments. The special judge did not have those luxuries. No, she just had Slicky Nicky freaking out on the phone. Nor does Alan point to anything suggesting the special judge is biased against Baldwin and Rosie. Oh, come on now. Oh, I can't read this. I can't. No way. The special judge said counsel made mistakes that rendered their representation ineffective, but her statements were not based on any extrajudicial source or any experience outside this case. Surely it doesn't need to be. It's about this case. It doesn't need to be extrajudicial prejudice or dislike or whatever. It's all about the case. Look at the case. Oh, just dig a little bit deeper, please. You're not going to do all you know, okay. Instead, her statements were based entirely on her observations within the case. And bias. There's no motivation to do anything like this if it's not through some kind of bias. While the conclusions that counsel were constitutionally ineffective was too harsh, she wasn't wrong to be deeply concerned that sensitive case materials had leaked. No, yeah, that is a concern. It is a concern that Mitch Westerman, Andrew Baldwin's friend, trusted, worked with him for 7 years in that very firm, goes in there in August when the depositions are all going on, of Holman and Liggett and all them lot, and he takes photographs. I say once again, for the billionth time, whose payroll is Mitch Westerman on? I'm determined to find out what payroll Mitch Westerman is on. Don't know how I can find that out, but I'm sure he is. I'm sure. Why did he sit on those crime scene photos for 2 months? Why? Because somebody told him to get some interesting and inflammatory and, would put the defense in a real bad spot and sit on them. No, come on. Her efforts did not reflect any bias or prejudice. Alan, okay. All right. So Judge and Massa and Goff concur. Slaughter goes in for the slaughter. Concurs in part. So concurs that, they shouldn't disqualify goal and they should deny the speedy. But he also wanted... he also wanted to keep the status quo. So I'm not going to read all this. It's like 3 pages, but... So the objection is less to do with the court's legal analysis than its bottom line issuance of a writ, given the procedural posture in which the issue of attorney disqualification come to us. Had the issue arisen in an interlocutory appeal or after a final judgment, I would be more open to Alan's argument that the trial court erred in threatening to disqualify his trial counsel. So basically, he was saying that this it kind of weakens the Supreme Court's original action judgments because they hadn't gone through the appeal process at first. So he wasn't going for it. So if you want to go and read all that, you can, but I'm not going to read it because it will infuriate me. I have skim read this earlier and it infuriated me, even just skimming. The court today flaunts our original action rules to award extraordinary mandamus relief in favour of Alan and against the trial judge. In doing so, we allow Alan to short-circuit the appellant process, muddy our own jurisprudence in this important area, and invite future deviations from our rules. In my view, these institutional costs far outweigh the benefits to Allen. For these reasons, I respectfully dissent from part 1 of the court's opinion and concur with part 2. So he's probably read Wheat or something. I don't know. Because it kind of sounds like what Gutwine was on about. So maybe he likes Wheat. Maybe he likes Wheat. I don't know. But yeah, so that's it. So I'm glad that, the other 4 understood the reasons why Richard Allen couldn't appeal. They could fully understand that, whereas Slaughter didn't seem to get that in his head. Oh, the Wheat emojis are out. I keep meaning to go and find Wheat and actually read Wheat. But I'm not that motivated, to be honest. So, yeah, we're all up to date now. So they've got their decision. I suppose it could have gone dreadfully wrong if Slaughter had his own way. What does the Wheat mean? All right, the Wheat. At the Supreme Court hearing, Gutwine, who was the attorney for Gull, was relying on one source, Wheat. and the Chief Justice Rush asked him, have you got any other source than Wheat? And he just kept going back to Wheat. Wheat. So it's a person's name, Wheat. So I put a Wheat emoji for members to use. So Penguin, you remember, you could use Wheat. You can use the custom emojis. So we've got Gull, we've got Come On Now, we've got Snark, we've got Cassie, Tilly, and can I use them? Oh yeah, look. There's Tilly. Colon. Wheat. There we go. All right, so I've been on here for an hour and a half. I expected it to take about an hour and a half, so I think that's probably good timing. I'm kind of expecting other people to go live about this, so I'm going to get off here and maybe catch whoever's live. Criminality, maybe. Defense Diaries, I don't know. I tend to, they tend to go on later because it's 11 o'clock in the PM for me now. So they tend to go on later. So I watch maybe the first little bit and then I have to catch up in the morning. But that's fine because I put everything mega fast and I can catch up in no time at all. So we'll see. All right. I'm going to call it a day here. Thank you all for joining me. Thank you for keeping me company. Got a little bit of a sore throat because I keep shouting when I do these live streams, and I shouldn't shout. I should talk in a normal tone, but I don't. I give myself a sore throat. I'll try to just lower the tone a little bit. But anyway, thank you, mods. I've seen some mods in tonight. I'm going to recruit some new mods, by the way. All you old mods, you're staying. But I want a few new ones as well, just to, share the workload. So I'll have a think. We've almost got 500 likes. Good stuff. So yeah, pop a like on the stream. It helps get it in the algorithm for replay viewers. Gets the channel noticed. Like all my videos. Like them. Love them. Because I do struggle with the algorithm a little bit, I think. I don't know. All right. Thank you all for the donations. You've been so generous tonight. And I shall see you tomorrow for another video and the Adam Montgomery trial. Oh, it's a bad one, that. All right. Good night, guys. Enjoy the rest of your day or the rest of your evening. See you soon. Bye-bye.